court notes that it also received a statement from Chrissy Kibby, and the court will consider that for portions of the incidents that were incapable of recall due to Deputy Kibby's lack of memory. A court should consider the following factors when imposing a sentence. Number one, reformation of the offender. Number two, protection of society. Number three, punishment of the offender. And number four, deterrence of others from committing like offenses. In this particular case, there are various factors that mitigate in support of the defendant. Mr. Gerou has struggled with mental health for a significant portion of his lifetime, and it appears that he became aware of his different various diagnoses potentially as early as age 17, which incidentally is approximately the time that many of his involvements with the criminal justice system began. The court does note that Mr. Gerou has a juvenile history dating from 2001, including an assault and battery, through 2002, and his adult history begins in 2004 and carries to present. Mr. Gerou has the support of his family, and I believe they're in the courtroom today. He is also a successful parolee, having completed one prior term of parole, and it is noted that he received extensive mental health services and also resided in an AFC home while on parole. It appears that the majority of his success having paroled came from the regular administration of psychotropic medications and remaining sober. And apparently during that time also he has had the benefit of steady employment and did not engage in any type of assaultive behavior while he's been incarcerated since this incident. The difficulty with this particular case is that the incident itself is so severe and traumatic, and the court is also very concerned about the explosive manner in which this incident happened. And when looking back over the mental health aspects of the defendant, and in particular those that are mentioned in the sentencing mitigation report for Mr. Gerou, it is documented that Mr. Gerou has had mental illness battles since age 17. During his lifetime, his family has sought various treatment through different avenues, including inpatient and outpatient treatment at Pine Rest and Forest View. And at some point in time, Mr. Gerou was even experiencing hallucinations resulting in paranoia. Instead of utilizing known methods, however, to a large degree, Mr. Gerou would self-medicate, and he would utilize alcohol and other substances either when his medication was no longer available or he chose not to take that medication. And that is the crux of the issue in this particular case. Mr. Gerou has a very unique disposition, to the extent that if he does not take his medication, it appears that he acts aggressive and violent. As it relates on page CFJ 284, page 2, the defendant has a documented history of failing to consistently participate in mental health services. He discontinues contact with the mental health programs, stops taking his psychotropic medications, and returns to using drugs and alcohol. He further has an extensive history of misusing alcohol and often becomes aggressive and violent. It is noted that he has 5 prior felonies and 18 misdemeanor convictions as an adult. He has been sentenced to probation 8 times and failed to successfully complete all 8 terms. It's also noted in a 2014 pre-sentence report that the assault that he engaged in with his wife was violent and unprovoked. And that is very similar to what happened in this situation. There was interaction with Deputy Kibby for purposes of investigating what appeared to be some form of careless or reckless driving, and the interaction quickly turned for the worse. And it was noted that Gerou's behavior was erratic, aggressive, and unstable. And at that time, Deputy Kibby was doing his best to administer the standard field sobriety test, at which point Mr. Gerou decided he would no longer participate, and he began to walk away, really leaving Deputy Kibby with no other choice but to try to stop that from happening and complete his investigation. Essentially, without provocation, Mr. Gerou turned around and struck Deputy Kibby so hard that he immediately lost consciousness. It's also noted that Mr. Gerou was acting erratic, uncooperative, and aggressive. In respect to the continuing behavior, it was only after a separate enforcement officer, Trooper Casey, drew his taser that Mr. Gerou complied and went to the ground. The circumstances are such that in this particular incident, apparently Mr. Gerou had been drinking. His parents were interviewed, and both of them indicated that his behavior was getting worse. In fact, it appears, based on CFJ 284, page 4, that they had told him that he shouldn't be drinking, and that further that he was off his medications. What the court has heard today is that Mr. Gerou has had an opportunity to look back on his behavior in this instance, and I don't doubt for a moment, Mr. Gerou, that you are sincerely remorseful for what happened on that date. But that doesn't explain some of your conduct and how quickly you reacted. I fail to understand how explosive that aspect of you becomes when approached with authority and asked to submit to something apparently that went off your medication you don't wish to do. And that is really the concern that the court has regarding the length of time to allow you in the community. When looking at your efforts at reformation of the offender, the court is typically very open, particularly in mental health cases, to allow individuals an opportunity to try to get treatment for those disorders. Because to some degree, much of that is outside of your control. It may be an aspect of your biological makeup. It might be some type of a factor that's beyond your control that happens to be in your family genetic line. But what's interesting to the court is that over the years you have received different diagnoses: bipolar, major depressive disorder, schizoaffective, schizophrenia. And what is more concerning to the court is that what's described as a documented history of medication noncompliance and abuse of drugs and or alcohol. But not only that, when those factors all converge, Mr. Gerou, the result is hostile and assaultive behavior. And that is the concern of the court, which shifts from reformation of the offender to more of a protection of the society aspect, which is also something that the court is to consider. I appreciate and can appreciate the fact that you were in a AFC home and that you were doing well, that you held employment. I think that's something that's very good. But what is concerning is that at the time that you were beginning to spiral, you didn't take the steps necessary to reach out to someone. And it isn't, at least in this court's opinion, that you didn't have the know-how or the opportunity to do that. You chose instead to self-medicate through alcohol and other drugs. And that engaged a violent component of your personality. One that I think that you even recognize, Mr. Gerou, because in your victim impact statement, you indicated that this never would have happened if you had not been drinking. In fact, it's reported that you stated if you had been sober, he never would have done what he did. You didn't mean to hit the officer. You were off your medications at the time, had been up for days, had been fired from his job, and was not eating. You also indicated that you did not plan this and that it just happened. That was a perfect storm for a very dangerous situation, and unfortunately, it doesn't appear that that's the first time that perhaps that combination has occurred, because as I look over your criminal history, you have multiple instances of alcohol and violence. Number 5 of 24, domestic violence. Number 6 of 24, dating back to 2007, police officer, assault, resist, obstruct, operating while intoxicated, second offense. 2009, attempted police officer, assault, resist, obstruct, domestic violence. 2010, number 14 of 24, attempt home invasion, first degree. Number 17 of 24, 2013, domestic violence. Another domestic violence in 2013. May of 2013, domestic violence, second offense. August of 2013, assault by strangulation. March of 2014, assault and battery. August of 2014, assault on a prison employee. Unfortunately, Mr. Gerou, there is an aspect of your personality that is dangerously assaultive to those that are around you, and the court cannot ignore that. I do recognize that, again, these are situations where you can become stable through medications. I hope that you are able to get the help that you need in the Department of Corrections. In fact, I'm going to recommend an order to the extent that I am able, that you receive all mental health treatment and services in connection with your sentencing. But because of your history, Mr. Gerou, and for all the reasons that I've stated herein, the court has no choice but to focus on punishment of the offender and protection of society. And in doing so, it is the court's hope that this will perhaps deter others from engaging in similar conduct, and or encourage others to maintain a healthy medication regime when they know they need that in order to lead stable lives. I do hope that you get the services that you need in the Department of Corrections. It is therefore the sentence of the court in file 2426413 FC that the defendant is sentenced in count 2, police officer, assault, resist, obstruct, causing serious impairment as a fourth habitual offender, to the Michigan Department of Corrections for a period of 19 years to 40 years with credit for 455 days served. This sentence will run concurrent to counts 5 and 6. You are to pay a crime victims assessment fee in the amount of $130. You are to pay court costs in the amount of $300 and a $68 state cost. In respect to count 5, police officer, assault, resist, obstruct, as a fourth habitual offender, it is the sentence of the court that Mr. Gerou be sentenced to the Michigan Department of Corrections for a period of 2 years to 15 years with credit for 455 days served. This count will run concurrent to counts 2 and 6. There is a $68 state cost in respect to count 5. In respect to count 6, operating intoxicated, third as a fourth habitual offender, it is the sentence of the court that Mr. Gerou be sentenced to the Michigan Department of Corrections for a period of 3 years to 10 years with credit for 455 days served. This count will run concurrent to counts 2 and 5. You may not drive a motor vehicle while your license is suspended, and your license will be suspended per the Secretary of State. You must comply with the vehicle immobilization as ordered by the court. You must pay restitution, $68 in state costs. If there is any restitution in relation to any of these matters, that issue will be preserved. However, in reviewing the report, I observed that I believe Deputy Kibby indicated that all of his fines were taken care of. However, if something does come up, Ms. Cook, you may petition the court on his behalf. I do wish to say that the court believes that the sentence is fair and proportionate. I am not inclined to go outside of the guidelines. I recognize that the guidelines are advisory per People versus Lockridge. I have considered the factors, I have considered the guidelines, and I do think that the sentence is fair and proportionate for all the reasons as stated. Ms. Cook, is there anything additional beyond appeal rights?
Yes, Your Honor, the people have a dismissal with regard to the remaining counts pursuant to the plea agreement. We have provided a copy of that to the defense as well as the written appellate rights.
Thank you. Mr. Gerou, in respect to this sentence, you have the right to ask the Court of Appeals to review this case and to ask for a lawyer for that purpose at public expense if you cannot afford one. The request for a lawyer must be made within 42 days after sentencing. You will receive a request form containing instructions informing you that it must be completed and returned to the court within 42 days after sentencing if you want the court to appoint a lawyer. Mr. Klein, is there anything additional at this time?
No, Your Honor, thank you.
Thank you. Ms. Cook?
Nothing further. Thank you.
Thank you. Mr. Gerou, I wish you the best. You are committed to the Michigan Department of Corrections for execution of sentence. Good luck to you, sir.
Thank you, Your Honor.
Thank you. We're adjourned.